Welcome to the Hastings Shadmehry Show with your hosts, Andee Hastings and Mally Shadmehry. Dive into the heart of family law as Andee and Mally bring clarity to legal challenges, celebrate client victories, and share the wisdom of their combined expertise. Get ready for a journey into empowerment and advocacy right here where your story matters.
Hello, and welcome to the Hastings Shadmehry Show, where we delve into the heart of family law and the stories that shape our lives. I'm Mally Shadmehry, and joining me is the ever insightful and beautiful Andrea Dyer Hastings. How are you today, Andee?
Doing great. I have a little bit of stress about the holidays. I think we all do, but doing great. How about you, Mally?
Same. I'm going to answer the question. I'm a diplomat today. I'm not a warrior today. I've had the warrior hat on for too long, living in the courtroom the past couple weeks. I'm worn out and ready to kind of become a human again and not just be a trial machine. So that's where I'm at.
You are a trial machine.
Whew, I think lawyers sometimes, if you're a warrior at heart like me, it's very easy to get sucked into, I call it a trial vortex. And it's very important to be able to decompress, take the time to come back down, get yourself in the gym. That's what I do. Whatever you need to do to come back down to earth so that you can be the best advocate possible and teammate for your partners and all that. So that's where I'm at.
He's always the best teammate, for the record.
Well, I learned from the best. So today we're going to talk about something that a lot of people come to us and they are very nervous about. And it's a simple phrase. It's called a contested divorce. A lot of people are very scared by the term contested divorce. And we're here today to put you all at ease and explain the reality of what that means. So Andee, could you answer for us, what is a contested divorce?
Absolutely. So it's actually much simpler than I think people believe or understand. A contested divorce simply means that you're getting ready to, or you're in the divorce process and you haven't reached a full resolution of your case, either by settlement or a court order. So we say every case is contested until it's not. So even if somebody comes in and their intent is to have an uncontested divorce, which we talked about last week, if they don't have a settlement yet, it's contested. Doesn't mean that we won't be able to take it in the exact direction that they want, but until we have a full resolution, it is contested because there are issues that are unresolved.
Agreed. And I always tell people that come to me, a lot of times when I'm explaining in a consultation, look, there's two types of divorces, uncontested and contested. They're usually going to get their panties in a wad, if you will, when I bring up the term contested, because that does sound scary. It sounds like you're going into a courtroom tomorrow and we're going to fight. And that is definitely not what it means. A contested divorce, actually, there's a wide range of where you're going to end up. In fact, I would say that the majority of contested divorces do settle. Do you agree with that?
Absolutely, I do agree with that.
And it just depends on how complicated the case is, what's going on with the other side, all of that. It just depends on how quickly you'll settle. So that's what Andee and I are gonna help walk you through today. When might the case settle, and what happens if it doesn't settle? Basically, what we're about to describe to you is how a normal contested divorce, where the majority of people will fall, how does it work? What's the lifespan of the case, and what are all the steps? So could you walk us through, Andee, sort of what happens after the consultation, when the attorney gets hired, then what happens in a contested divorce, and how do we get somebody divorced?
First thing that we do is we file a complaint for divorce. And there's always a question when you file the complaint. It's just to that's the vehicle that we use to get the case into the court system. There's a lot of things that we address in it, but we don't go into a ton of detail. And probably one of the biggest questions I feel that people ask and makes them so nervous when they're ready to initiate that process is, how are we going to let my spouse know? Mm-hmm. And so there's a couple of options. There's really three options, I think. We can send them a packet of what we have filed and give them the opportunity to acknowledge service. That's kind of a low-key way if you're trying to set the tone that you want to work through this in as amicable a fashion as possible. We often do that. We can have them served by a private process server, or we can have them served by the sheriff. obviously, if we're doing the sheriff, then there are specific challenges because people are generally more upset to get served by the sheriff.
Yeah.
That's the first thing that happens.
Yes. And I feel like a lot of family law attorneys don't put a lot of thought into that or hold their client's hand in determining how are we going to serve this person. But it's just a procedural requirement. The person has to be served via the acknowledgement of service that Andee mentioned. That's the nice way to do it, the polite way, if you will, or by a process server or a deputy going to serve them. It has to happen, or else the case technically is not pending. Another thing that I get asked a lot is, well, what grounds are we filing under? There are 13 different grounds for divorce in Georgia, and we'll talk about that some other day and how that all affects your case. But there's a lot of things that go into that complaint that go beyond just what meets the eye. And you do have to put that in there. And sometimes it's scary to put in a complaint for divorce that I'm seeking a divorce not only on the grounds that the marriage is irretrievably broken, but also on adultery or cruel treatment or habitual intoxication. So my point is, you have to have a great family law attorney. I know we talk about that a lot. But, we're going to repeat the important things that y'all need to be absorbing. You've got to find an attorney that's going to curate the experience on the needs of you and your family. So once the client approves of this complaint and we really hold their hand to determine how is the best way to serve this person, we make sure that our clients are very well aware of when this person's going to be served. We make sure the children aren't going to be around to witness that. You wouldn't believe how many times irresponsible attorneys allow service to happen in front of children. It's just something that they don't need to be seeing. So, all right. So once we get the person served, that means the case is now pending. The clock is ticking. That can be very valuable when you're trying to settle a case. Sometimes, a lot of the time, you've got an opposing party that is going to drag their feet and try to intimidate the other spouse, and they're just going to try to scare them, and they really don't want to settle. So serving them is a lot of the time is just a necessary evil so that the other side understands this is real, it's happening, you're not going to drag your feet and going to try to control me anymore. So after service, what happens, Andee?
Well, one quick point on not dragging your feet. Some people really do want to send a message of intent to work together to find a resolution by sending an acknowledgement of service. But make no mistake, the other side is given a deadline. So if the other party is somebody who is going to try to drag out the process, who wants to deny the reality of the divorce, anything like that, we give them a deadline, and if they don't comply, we serve them through a private process server. That happens every single time. People ask me that all the time. Well, they're not going to participate. And we have ways to deal with that.
Because, yes, they are going to participate.
Well, it's going to happen to them, the divorce, even if they don't want it to. And that's what some people don't understand.
Yeah.
Is if my spouse doesn't want a divorce, does that mean I can't get one? It does not mean that in the state of Georgia. So, we have to deal with that on the front end. How we initiate the case, as we've discussed already, is a very strategic process, more than you might think that it would be. It definitely sets the tone. And, one thing that I say at the beginning of cases is hope for the best, prepare for the worst. I can be as nice and amicable as possible until I'm not. And we will send the right message, but if we need to get into the ring, that's absolutely what's going to happen. So don't misunderstand our polite niceness at the beginning of the case. If the other side is going to go that way, we're going to take them that way. So next step, though, enough about service. The next step is that they have 30 days from the date of service to file an answer to the petition. And usually they file an answer along with a counterclaim alleging that they too want a divorce and the things that they think would be appropriate to seek.
Yeah, and the comment I have there and what I tell our clients is, look, do not get bogged down in the complaint and the answer. Those are procedural requirements. When you have a contested case, which most people do, you're in the norm. You're in the majority if that needs to happen. And these are notice pleadings, the complaint and the answer, which just means you're putting the other party and the court, really the world, on notice that, all right, we're getting a divorce, and here are the general things that I'm seeking. And it is not uncommon that, for example, both spouses are going to they're both seeking primary physical custody of the children. They're both seeking attorney's fees. And that attorney's fees one that goes in the complaint and the answer. And it usually will strike a chord within a lot of people, makes them upset. Oh, he's seeking fees from me? Oh my God. Well, your lawyers would be crazy not to put that in the complaint and the answer. It's a notice pleading, which means if you don't put it in there, you basically don't get to ask for it if you ever have to go to court. You have to preserve your right to ask for certain things in these initial pleadings. That's all it means. So these are just procedural hurdles, but because they're at the beginning of a case and emotions are very high and you're still, your lawyer should still be earning trust with you right now, these things feel heightened to a lot of litigants. And really, they're just standard. And the most important part is just to be able to trust your attorney's lead. Because what needs to happen, Andee, I'm kind of asking you, when complaint is filed, they have 30 days to file an answer. What are we kind of doing in that interim?
Well, at that point, we're trying to figure out what are the assets, what are the issues, and what are the assets. We've identified the issues in the consultation, and we've also identified what our clients, if you were drawing a picture of your perfect world of what this would look like afterwards. So we start with that because we can help clients understand what's reasonable, how we'll fight for certain things, and if something is just simply not possible. And then as the case has been initiated, we're gathering information, documents, that sort of thing in order to put together the financial picture, perhaps have a better understanding of how the parties raise their children together. So we're having our client, to the extent that they can and have access, gather as many of those pieces of information as possible: bank statements, tax returns, retirement statements, all of those sorts of things. And some people, they come in and they're scared because they're like, I don't have access to this information.
That's the norm.
Yes, I agree with that. And, what we say to that is, do not worry. We're going to put together in our minds information on the things that we know, and then we're going to create discovery requests to send to the other side to provide the documents that we don't have. And that's the process that we're in after the case has been initiated, is what we call the discovery process.
Yes, and that's really an important component of the contested divorce. Once you file a case, you then enter into a world where you have discovery power under the law. We can seek documents. We can send subpoenas to banks, to employers, to anyone we want to obtain information. And so we'll talk briefly about discovery again in a second. But one thing that we get asked a lot is, does it matter if I'm the one that files for divorce or if my spouse files? Does it look bad if I file for divorce? Is that going to hurt my case? Or should I be the one that's the defendant, the one that's served? Typically, that's for you and your lawyer to figure out at the consultation if there's any strategy that would be beneficial there for you. My preference is to be the plaintiff, to be the one that files, because if you go to court ever, and you might not ever go to court, even if you're in a contested divorce setting, but if you do, the plaintiff gets to talk first and last in court. So that's just the trial strategy that I like.
Me too.
But otherwise, in my experience, absolutely not. A judge isn't going to be like, oh, you're a terrible person because you're the one that filed for divorce. That is just not a thing. But that's for you and your lawyer to talk about. And if you are the party that's getting served, if you're the defendant, the one that your spouse has filed for divorce, and then you get a knock on your door and there's a deputy or a process server and says, you've been served, don't panic. You have 30 days in which to file a response. So the most important thing you need to do is just go find a great lawyer, talk to them, tell them I was served on this date. They have to know that. It's very important. You don't want to let that 30 days pass without filing an answer. So that's the rule of thumb there. You get served, don't panic. Go to a lawyer. They will handle it. And you guys got to file a response within 30 days of service. So we were talking about discovery. And basically what discovery is, it's the fact-gathering process, as you alluded to. And it's technically a 6-month time period in Georgia that opens up. And in that 6 months, your lawyer can send all kinds of requests to the other side, to, like I said, financial entities or whoever, so that we can put together a full financial picture. You don't have to use the full 6 months. And if you need more time after the 6 months, there's a way to get more time to gather more information. And that happens in some very complex cases. So Basically, it's very similar to what we just said about the complaint. Once discovery is sent, the other side has 30 days in which to send back what you need. So I think the point we're trying to make there is that in contested divorces, it's very normal. We'd have to do a little bit of discovery, a little bit of fact gathering, so that we could come up with a proposal of settlement. Some cases don't need it, but some do. Most of them do. Don't panic if you're in the discovery world. You're in the majority with that. Very rarely do we settle a case without discovery. And if we do, it means that the parties probably haven't been married very long. They're usually a bit younger. They haven't acquired a lot of assets. We don't have really complex custody issues. So that's a little bit more rare.
And they both have equal access to information, I would say.
For sure.
Right.
And ideally, two great lawyers that aren't going to take idiotic stances. That affects things.
That does help.
Okay. So let's say, Andee, that we've gotten enough information, whether we did discovery or not, in a contested divorce. We got enough information so as to draft a proposal of settlement that our client feels good about. What do we do?
Well, we can do it a number of different ways. We can go ahead and draft a settlement offer, which is a letter, and it's got all the main topics that we would want to address in a formal settlement agreement and a parenting plan and a child support addendum, if that applies. And we can do it that way. We can send the letter over. We can pass those back and forth. Or depending on where the parties are, because sometimes people have had conversations with their spouse. They do have an idea, okay, she's going to keep the house. I've agreed she can refinance within X number of months or whatever that is. So we can start putting together a more formal document, which can be molded into the ultimate agreement that the parties reach. And the same thing with the parenting plan. You know, parties often have an idea of how they want parenting to go, and we can begin putting together something that embodies our understanding, either A, of what the parties have discussed, or B, what our client is seeking in order to create a jumping off point in order to move through settlement discussions. But Mally, I wanted to ask you, what happens if in this portion of the case, there are some problems, like both people live in the house and one really needs the other to get out. There's a lot of tension, or somebody stops paying the bills or cuts another party off from finances. Can you talk about that piece of the process?
Yes. Part of the beauty of having a divorce filed and having that power, meaning that you can litigate if you need to, if you need protection, is that you can go to a temporary hearing. That is an interim hearing. It's a trial. It's a baby trial sometimes, but it is what you'd picture on TV. But it's interim. It's not the final hearing. It's not the end-all, be-all to the entire case, but it means we've got interim issues, Your Honor, that we can't reach an agreement on, and unfortunately we need a judge to step in so that we can get the parties on to some playing field that they can live with right now, because what they're living with right now is not sustainable. It's either a toxic environment, abusive, financially abusive, we'll see a lot, one party cutting the other party off from finances altogether. And so we've got to go to court to say, well, he or she has cut the other one off, Your Honor, and we're going to need temporary support. We need a temporary parenting plan. We need temporary attorney's fees potentially. So you and your lawyer would come up with, what are basically the biggest key there is good communication with your lawyer. Your lawyer will determine when and if it's time to go to a temporary hearing. And different counties in Georgia do that differently. Some counties are going to require a mediation before a temp hearing. Some parties are not. Some counties send you to an automatic, basically, opportunity for a temporary hearing every 30 days at the beginning of your case. So it just varies by county, which makes it very important that you choose a lawyer that is familiar with your jurisdiction and knows how each county wants to do certain things, because that way you're going to save money and be more efficient and have a lawyer that's going to get you to the end result more quickly without having to go through the sort of rigmarole of what does this judge do? And you're going to spend more money for a legal team to go figure that out. So temporary hearings are a great way to get you to, I guess, cruising altitude until we can get you to the end result. They can be expensive, so it's something that your lawyer would talk to you about to plan that appropriately. And I did want to ask you about mediation, Andee. Can you explain to us at what point do we see most cases going to mediation? How does that work?
So again, it depends on the county. In some counties, we have to attend mediation before we have any hearing. But Typically, mediation organically happens when both sides have the information that they need in order to enter into meaningful, informed settlement discussions. So for us, with our clients, if I don't have all of the financial information to form an appropriate financial picture, I'm not going to make my clients spend their money going to mediation when we don't have everything that we need. I absolutely, always be prepared, the Girl Scout motto, and we definitely follow that. So we want to have all of the information, because for us to do our jobs for you, we have to be able to tell you what is the risk if we take this position in court, or, we can balance this asset with this asset. If we don't have all the information, we cannot do that. So, basically we have all the information. We schedule mediation with a third-party neutral. And that also, who that is, will depend on the county that we're in. Sometimes it depends on the judge. Sometimes it depends on the personalities of the parties. We want to set up a mediation situation that has the greatest opportunity for success. So, for instance, if you have a spouse with a very strong personality, that may inform the mediator we pick or suggest to the other side, either based on their personality, if they're male or female. My point in this is there is strategy at every single turn of this process. Every single thing that happens in a divorce case, we are strategizing what is going to put our clients in the best possible position to get the outcome that is the best for them and what closest to what they want.
Agreed. On the mediation front, in a contested divorce, I would say probably 85% of my cases settle at mediation, meaning my client won't ever go see the courtroom. If you see me in court, honestly, it really means the other side has taken an inappropriate stance and I just can't get past it. So we're going. Judges know that. A judge is going to know, okay, Mally Shadmehry brought a case to court. It must mean somebody wasn't being reasonable. I mean, your lawyer's reputation matters. So that's a different topic, kind of melding into the trial strategy, topic. But like Andee said, a family law is a small world. We are going to know who a good mediator is. We've worked with these people for a lot of years. We're going to know whether they're going to be conducive to settlement in this case or not. Another thing that is important to note about mediation and family law attorneys is that we are business advisors. That's what we do for you. We are here to bridge the gap between emotion and business, which means, think about it like this. Your mediation, you're going to the settlement table, and no, you're not sitting at a table with your spouse in the same room and your lawyers are yelling at each other across the table. That's a lot of my clients picture that from TV or whatever. And that would be hilarious. And we would put on a show for you doing that, but that's not how it works. You and your lawyer are in one room, your spouse and their lawyer in another room, mediator goes back and forth. And we'll do a separate episode on mediation specifically, but you're sitting at the table to make business decisions that are going to impact you and your child's life forever. Money, child custody, parenting time, all of that. So we do not go to the settlement table without being completely prepared. It's just like any business deal. If I'm going to sit down and make a multi-million-dollar deal for my business, do you think that I wouldn't have advisors with me every step of the way to make sure that we're crossing our T's and dotting our I's and I've got a document to back up why this is a good deal for me? We make sure our clients can see the full picture. And like I said, we're here to help take the emotion out. You don't make smart business choices when you're involving emotion in that. So we bridge that gap. And that's something to be expected at mediation. For you, it's really difficult, but you've got a business advisor here that's not going to let you agree to something stupid.
Or will at least give you all the scenarios in which that's not a good idea before doing that. I find, Mally, and I'm sure you do too, that we have people that by the time they've reached mediation, sometimes all they want is to be done. And they're going into it with a mindset of, I'm just going to make a deal. I don't care what it is, just so that I can be done. And
I would do that if I was a litigant and not knowing what I know.
Right.
I'm very much like that in my personal life, and I have to have experts help me.
And we don't, it's not that we don't let our clients do that, but we're very careful about that. I mean, at the end of the day, you are an adult, you can make decisions for yourself. But we're going to warn you vigorously about that, because while it may be good in the short term to get free of this situation, you will regret it in the long term if you make a deal simply to get done quickly.
All right. So let's say if you settle at mediation, then your divorce can be finalized on paper. You never have to see a courtroom. But can you briefly summarize what happens if you don't settle at mediation then, Andee?
Well, if we don't settle at mediation, we're going to trial.
Go to trial.
Which is a place that we love. Because like Mally said, if we're in trial, that's because somebody has taken a boneheaded position and we're going to fight it out. And, you know, I hate that for clients sometimes because they really just want to be done. But sometimes we simply have no choice. And so we're preparing for trial. Another option is arbitration. If we're in a county where there's a pretty big backlog and it's going to take several months to get on a trial calendar, we might talk to opposing counsel about doing an arbitration, which is essentially the same thing. You're designating somebody to listen to the facts of the case and the evidence and render a decision. So one way or another, either by arbitration or by trial, we're going to conclude this case. Typically, our trials are bench trials, which means they are in front of the judge that's assigned to your case. There are allowances for jury trials in the state of Georgia. We're one of the 3 states in the union that allows for a jury trial in a divorce. And we've definitely done those before. That it's a very specific circumstance in which you might want or consider a jury.
And juries can never decide custody.
Right.
So by default, you basically have to have a trial custody in front of a judge. Jury tries the rest. But
exactly.
The lifespan of a contested divorce, the length of time that we get asked about that a lot, you know, so it's going to vary. As you can see, it's going to range. Do you settle early on? Did you need to do full discovery? Did you need to do a couple rounds of discovery? Did you need to mediate to get it done? I mean, it's just going to vary. Typically, mediation is going to happen anywhere between 1 to 6 months since the divorce has been pending. Sometimes it could be later, but 1 month would be very quickly. 1 to 6 months is about when you're going to hit a mediation. And like Andee was saying, courts can be backlogged. So you just never know when you're going to be reached on a trial calendar, either for a temp hearing or a final. So on average, I would say if you're going to have to go all the way through a final hearing, you couldn't settle beforehand, you're going to be litigating probably at least for a year to 2 years, depending on how complex it is. If you settle, then I would say that's just going to really vary by case. Settlement, you have more power and, an end in sight that's more in your control.
And that's and I think any judge would tell you that too. Judges have told us and our clients that before, really our clients they're talking to, because we know this. But, when you settle a case, you have taken control of your future. When you hand it over to a third-party decision maker, you don't know what they're going to do. I mean, our job is to present the evidence, the information, be persuasive, make the arguments necessary to obtain what you want. But anytime you hand over the decision-making on the most important aspects of your life, your children, your money, those sorts of things, you are relinquishing a level of control that we definitely counsel our clients about when we're going through the settlement discussion process, mediation, and or preparing for trial.
So this concludes our little session on contested divorces. If you fall in that category, don't panic. Don't be scared of the word contested. It's highly likely you'll still settle. And if you don't, you're going to make sure you have the best family law attorney that knows your jurisdiction, knows the judge, knows what to do to get you out of this. So with that, we'll leave you and we'll see you again next time. Thank you.
See you next time.